It's some big news.
Yeah. Ladies and gentlemen, the motion to dismiss made by the Walt Disney Company in the case involving Gina Carano has been officially denied. Ron Coleman, where are you at? You got the link. Hop in here if you can, my friend.
How fascinating, how unsurprising, but still all the same, how very pleasing.
Isn't it? And you also seem to, based on what information we had from the hearing that happened maybe about a month ago, you seem to recognize the fact that the judge in this case, who is not exactly a Donald Trump MAGA judge here, let's put it that way, right? This is a Democrat-appointed judge, somebody that, in theory, if you want to play politics, would be politically more favorable to Disney. This judge did not seem to want to just dismiss this case out of hat. I mean, she seemed like she wanted to hear more, and you called it, and here we are. So what do you think?
I was contacted by our friend Jonas just a couple minutes ago, and I've got the opinion open in front of me. One thing that I find fascinating, I've done a lot of litigation in California, but I'm not admitted in California. My experience has always been that a sort of preview opinion is frequently issued by California federal judges, where they tell you what their intentions are. Here, there was and that usually takes place fairly soon after the argument. We waited a little bit longer, but got the full boat. This is a 23-page opinion, and that's on what we call California paper, which is a little bit more tight. The lines are numbered, and it is a little bit tighter than double spacing. This is a judge who has very impressive credentials. She has done the heavy lifting here. And it's an important point that she makes. I'm really just scanning it. But it's fascinating that the defendants, Disney, did not actually contest the constitutionality of the Unruh Act, which is the California law that governs the employment actions taken in connection with political speech. Just reminding everyone that that's a unique feature of California law. This is not a First Amendment case as such, but Disney could have challenged the constitutionality of the Unruh Act, but instead said that although defendants do not appear to contest the facial constitutionality of the statute, defendants contend that as entities that do create speech products, they enjoy the right to make decisions about what to say in their own art and how to say it, including by selecting the individuals who perform or otherwise create that art. I'm sure there's a good tactical reason for not attacking the statute facially as unconstitutional. And there may very well be a constitutional objection to it. Disney had its reasons, I'm sure. They may have been political. They may have been, again, tactical. But what it ends up asking the court to do on a motion to dismiss, which means before anything is proved, before any discovery, was to really slice a very, very fine figure through the alleged facts. And I think it's going to come out, and I haven't had a chance to really read the opinion, but that is probably what the court declined to do, because as we discussed in the previous episode of your show, just talking about this case, if indeed there is a smoking gun email, there may be, there may not be, an email, text, graffito that says, we've got to punish this woman for her free speech. I don't care what it does at the revenue-wise. Our political constituency or our union or something requires that we shut this woman down. Then that would demonstrate that their decision was not, in fact, based on solely business calculations. I don't know that the court does go there, but I do see here, to prevail on their defense that the expressive association rights
what
bar plaintiffs. I'm on page 15. Bottom of page 15. To prevail on their defense that their expressive association rights, that's a First Amendment based defense. So first, Disney is saying we're not saying the statute's unconstitutional, but we're saying that as applied here,
Mm-hmm.
our right to only have Disney products or Disney media associated with messages that we approve of is a First Amendment association right. The judge says that to prevail in that defense, the defendants would have to show that any impact on their claimed associational freedoms cannot justify California's interests, which they don't challenge, in eradicating sex-based discrimination and employer pressure. I didn't even get into the sex-based on employee political activity. At this stage, defendants have not made such a showing. So it's a legal argument which they might ultimately be able to make after discovery. Disney might come back and say, we did a survey, or we brought in three experts from the industry, producers or finance people, and they all said, if Disney would have kept Gina Carano in, it would have been a disaster compared to how great they did without her.
I have a feeling, I don't know this for sure, but I'm going to go out on a limb and say I am 95% sure that didn't happen. A lot of this, and we because we were covering this like the night it happened when she got canned and the news broke, and we remember this. And of course, we've got friends that know Gina. Everybody knows Jay, Drunk 3PO. I don't get the sense that's when a lot of this was inside Lucasfilm. This was the Lucasfilm girls club that was in there that didn't like Gina. I could be dead wrong. This is just Valliant Renegades. Really strong gut feeling here. You know, this is, I will stipulate that. But what I find interesting here is that at this point, Ron, okay, the judge has denied Disney's motion to dismiss. Where do we go from here? Disney can walk in and do a settlement offer. They go to discovery. What's the story?
Oh, you're depriving me of more legal analysis. Hold on, not so fast. Do we have the time? Can you give me another 5 minutes on this?
Go for it.
Let's jump to page 19. Okay, I'm doing this absolutely on the fly, but no one better qualified to pretend to be able to do that than I am.
That's why you're here.
So right in the middle of 19, here in contrast to two other cases, this goes to the question, again, which we discussed in a previous episode. How much do consumers think that what Gina has to say is attributable to Disney in any way? The complaint does not take issue with the message or content of The Mandalorian. In other words, not the complaint, but rather what Gina said. Mm-hmm. She does not allege she was fired because defendants have fewer females in the role. She contends, I'm skipping, that defendants fired her in retaliation for off-the-job political speech after attempting to make her renounce those comments and, quote, re-educate her.
Yes.
So now, to some extent, this goes to the question you just asked me: what would have been her options here to get her job back? Defendant's motion, bottom of 19, misconstrues the proper framework for evaluating factual allegations within complaints. That's really a damning thing for the judge to say, because Disney's represented by one of the top law firms in the world. Mm-hmm. And the issue of evaluating factual allegations within complaints is first-year law school stuff. She's saying she knows that they didn't misunderstand the standard. She's saying, you tried to bullshit me. Or they urged the court to defer to their claim that they viewed plaintiff's speech as compromising their expression. This goes to my point again. What is their real reason? On a motion to dismiss, however, courts construe the pleadings in the light most favorable to the non-moving party. And I've written about this actually in a standard textbook for federal litigators. Although defendants might, with a more developed factual record, be able to prevail, the complaint lacks allegations to support defendants' assertion that her presence interfered with their choice not to produce a show associated with their belief. This goes along the lines of what I was talking about, is we don't really know why Disney fired her. If the allegations of this complaint are correct or are proved to be true, which they must be assumed to be true on a motion to dismiss under Federal Rule of Civil Procedure 12b-6, then you can't dismiss the complaint. And if they're proved to be true, Gina wins. Now, to go back to your big question, what next? I don't know. It does seem that Disney, well, listen, losing a motion like this inevitably puts you between a rock and a hard place.
I would imagine.
Because on the one hand, You might very well, quite reasonably, think Disney does not want this to go to Discovery, not because this is one of those cases where there's going to be this super juicy smoking gun. Pardon me for mixing metaphors there. But rather because if they don't have a strong evidentiary case, there's going to be a lot of sympathy for her. She's going to go to the jury. There is going to be much more disclosure about the way Disney makes decisions, again, even without that smoking gun, than they want to have out there. And they might lose. On the other hand, if they settle, they have really been neutered. And so has the rest of Hollywood and the entertainment business. And ladies and gentlemen, this happened in California. In California, in the Central District of California. You know how much entertainment law is litigated and decided in the Central District of California?
Pretty much bunch. All of it, almost.
And because in federal court, there is no appeal from an interlocutory decision, meaning one that is based on an order, an interlocutory order, which is one that does not dispose of the case. Disney can't appeal this until the case is all over. Now, one district court's decision is not precedentially binding on any other district court, although it's persuasive. Mm-hmm. And given the notoriety of this case, it's likely to be very persuasive. So it is a soft precedent, and it's going to cause a ripple throughout the world of entertainment and the nexus of the entertainment and the politics that you talk about on this program so often. So this is a bombshell. Which way is Disney going to go? There is really no way to predict, because the expression I always use is you can't armchair quarterback anyone's lawsuit unless you got that file yourself and you really know what the other side, what both sides' tolerances are, what the money numbers are, what's really in that file drawer, what's really in that email box. You can't tell. But this is a super, super bad outcome for Disney. And this judge gets all the credit in the world for going against the woke trend in her neighborhood and in her court. I have been rudely screwed by this court on political grounds. She absolutely came through, went the right way. I'm really looking forward to a leisurely reading of this opinion.
Yeah, it's really interesting considering where they are, who this judge is, which side of the political aisle she comes from. Obviously, to me, as a layperson reading this, or just looking at the decision casually, you'd have to assume that there must really be something here for this judge to feel like, I don't have a choice but to let this go through. I mean, there's no way.
Let me be clear to you that is not necessarily the case at all.
Okay.
In other words, all Gina said, and in good faith, she could say it. If I were her lawyer, even though I haven't met with her, I've never met her, I can say that this is something that you can allege. Based on what I do know about the case, she can allege, and it's plausible, which is the standard under Federal Rule 12b-6, plausible for her to allege the reason she was fired was because of the politics.
Yeah.
And not because of the politics as it would affect Disney's bottom line or top line, but rather the politics just to punish her for her political statements. That's an allegation you can make and say, I want a chance to look through your databases, through your Slack and all that stuff and see if it's true or not. Mm-hmm. It may come out that she doesn't find a damn thing, and that this is based on nothing but spreadsheets and nothing but hard-ass cold calculation. And in fact, that maybe it even has to do with union negotiations. All possible.
Sure.
Then it gets really interesting. Gina might come up completely empty. So the judge's decision didn't have to be based on there really being something there. Mm-hmm. But you and I both know, of course, there's something there.
Yeah, no, there's something there. I can't speak to specifics, and you can take from that what you will. But I know that you just imagine, let's say, if you worked in a job like that for a few years and you were on private communications with the rest of the team and you were getting emails.
As your lawyer,
yeah,
I don't want you to tell me anything that's going to make you the subject of a subpoena.
Just saying, use your imagination. I would
take that back.
imagine somebody working in an environment like that would probably have a lot of stuff like, which is why they are where they are. My point is, I highly doubt that Gina's showing up completely empty-handed with this one. And the question I asked her last week when I was in Knoxville, and I said, thank you for doing what you're doing. The Walt Disney Company loves to run roughshod over people. If they come back with this, if it doesn't get dismissed, now it's not getting dismissed. We have now passed that threshold.
Do you have someone on the extensive Valliant Renegade staff searching the internet for all the people who predicted that it would get dismissed?
Oh, we don't have to search. We already know who they are. They're the same people that said Ron DeSantis was going to lose and Florida was going to lose. It's all the same people. They're always wrong about everything. No, I asked her, I said, if we got to this point and the case is now proceeding, it doesn't get dismissed, if Disney comes in and offers you a big fat settlement. I mean, I said, what would you do? I said, I know that these are Elon Musk's people. He's picking up the check for this. He's not going after Disney for money. But I asked Gina, what do you think you would do? And I said, I know you probably can't specifically say what for legal reasons, but I'm just curious. And she said, in so many words, she said, we are prepared completely to go all the way with this. So very confident. Doesn't sound like they're interested in.
But every man has his price, and so does every chick. And also, you must always take the position that you're prepared to go all the way. Otherwise, if you say,
right,
I'm not really up for this, I'm hoping that I want to get out of this. I got tuition to pay. Then you've shown your hand. But it is one thing that helps. You mentioned the Musk funding.
Mm-hmm.
The fact that this is not being handled on a contingency basis, I assume, since Musk is funding it, means there won't be any pressure from the lawyer, which should not exist, but which people are human. Sure. One of the issues that does come up in the contingency context is the lawyer wants the cheap and dirty settlement. Yep. The fast settlement, which is, even though I might win $30 million, this is not that kind of case, I don't think, but I might win a larger number if I take it to trial in 18 or 24 months. I'll be super happy taking a portion of that today and not doing the work. It's the kind of thing that you could build a career on. This is a fantastic outcome. Although then again, so is California's Communist Protecting Unruh Act.
Yeah.
I'm just thinking of all the stuff I get to buy for Christmas.
There you go.
Because this is a gift.
Oh, yeah, it is.
Oh, baby.
Make sure you're subscribed to Valliant Renegade and join us every Sunday at 6 p.m. Eastern for the so we'll get into it. We've got somebody joining us here, and I know there's a little bit of news today coming out. A lot of you have seen articles and videos out there today. How do you like the new hat? Some articles and videos out there on there is an updated legal filing for my layman's idiocy. That's what I'll call it. We'll have an expert here to tell you what it's all about in just a moment. But we had a filing today, or in the last couple of days, I should say, in the Carano case. And of course, everybody's seen videos. People are putting out all over YouTube saying this could be Kathleen Kennedy being dragged into court, Pedro Pascal being dragged into court, so on and so forth. So we want to talk about perhaps some of the veracity, or maybe the lack thereof, of some of these claims. It may be a possibility, it may be not. But of course, we like to have the people who actually know these things come in and talk about this and explain this to us. So I'm going to bring him in just a second. I see him getting ready backstage, or give me a thumbs up if you're ready to go. And okay, thumbs up from the man. Ron Coleman is here joining us.
I'm here.
You are here, sir.
In my diminished state.
And you're diminished. Speaking of me getting over the crud, you are too.
Boy.
Yeah.
Yesterday was like a real lost day. That's pretty much how I got the Rona in the first round. And that's pretty much how it went for me. But I mean, that was the killer Rona, right? But I wasn't a senior.
Yeah.
I wasn't a senior citizen then, and now I'm over 60. So I should be able to do like handicap parking or something.
You are still a young man to us, Mr. Coleman.
Yes,
So,
well, I hope to be around for quite some time, and I'm looking forward to this discussion. I'm ready to speak generally about these fascinating developments. It's amazing what the magic of online court filings has done for the journalistic enterprise.
Isn't it though? I think back, just not that many years ago. I mean, in the last 10, 15 years, you didn't have the proliferation of these kind of things like you do now, to where they're so readily accessible, and not just to the people that have like LexisNexis and stuff like that, but I mean to the people that have Deadline magazine, that put hyperlinks to these things in there. So we definitely want to talk about that since you're here joining us now. Bear with me 1 second. I want to grab a couple of things here real quick. Thank you very much, Tender Warrior, for the $100 super chat, the 20 gifted Valliant Renegade channel memberships. God bless you. Thank you for being here, my friend.
Awesome.
Thank you for your generosity. Great way to close out the month of July. Get a little extra boost there at the end to help pay the YouTube bills, as it were. Thank you so much, Tender Warrior. Much appreciated. And also to Sky Cast for gifting 5 Valliant Renegade channel memberships. Thank you, Sky. I don't believe I've seen that name pop up on my gifted membership feed in super chat feed before. So thank you if this is your first time sending something in, or I know some people change their handles on YouTube from time to time. So thank you so much. Brandon also gifted a Valliant Renegade channel membership. Let's go, Brandon. There you go, right there. And then Infinite Wanderer for 5 says, you hear about Endemian's Amazon Warhammer leaks? I did. He says it's canceled because Amazon wants to Rings of Power it, I'm guessing is what that means. But GW wants actual profit, he says anyway. GW. Wait, who was involved in that?
I see GW. I'm thinking George Washington. I'm sorry.
Yeah, George Washington, George Wallace, the comedian. Wait, GW. Wait, why? I'm just blanking out on this. It might be the game. Is that the game dev?
Gina, what would you bid you at?
That one. Wait, let me check the live chat. Somebody probably already answered. Games Workshop. Thank you. That's it.
Oh,
okay.
yeah. Well, gamers like us, how can we miss that?
Games Workshop. I was trying to remember the name of the dev because I was actually reading stories on several different game devs today, all having issues. We've been following, the recent stuff with Ubisoft, who does Assassin's Creed and all this. You look back in 2021, they had a stock price of $81 a share on the French exchange, actually the Parisian exchange where they're based. Now they're worth $18 a share. There's a lot of game companies suffering out there, and not for lack of trying. So sorry about that. Thank you. Yes. I think I wonder. I know there was a rumor out there about that with the Warhammer thing that, Cavill, they wanted to get Cavill on board, and then we heard rumors that Henry Cavill, of course, recently Superman of DC, had his big cameo in the Wolverine and Deadpool movie this weekend. He kind of got disenchanted with the idea after Warhammer, according to many out there, and I don't follow the game at all. I'm just repeating what I've heard from friends I trust, that it went quote-unquote woke with a lot of things, and I think it ticked off Henry Cavill, which is a very plausible story to me, considering that's basically what happened with him, his falling out with Netflix when it came to his portrayal of Geralt on The Witcher. He's a huge fan of The Witcher and a huge fan of that character. He really wanted to play it, did a fabulous job, and then changes to the story to make other off characters, more girl bosses in the show, deviated from the game. Henry Cavill was like, go ahead and do what you like. I'm out. Have fun. Good luck with it. And basically the show fell apart, and I don't think it's getting renewed anymore because Cavill was the draw, right? So if that happened, if the same thing happened with Warhammer, they might have bailed out early without say, well, if Cavill is not interested in it, then we best just stop right now. So, all right, let me bring up this. Well, we have somebody joining us. Hey, Tom, good to see you.
All right, Mr. 420.
Yep. I think probably, I know, right? I think, if I'm not mistaken, so StreamYard has this thing where they default, I think, 3 hours in it, like ahead when you go program it, and it must have been 1:20 my time or something. I don't know. It's probably, I think it was right after I got back from lunch, so that probably was the case.
Freudian slip.
I guess.
Smoke weed every day.
Thank you. Yeah, there we go. That was it. All right, let's bring this
like,
up.
I got to get my smoke on before the show. No, I'm just kidding.
No, it's actually I can say with a straight face, never done it. Never done
Really?
any drugs. No, I had a number of friends growing up, especially in
missing
New
out. No,
Orleans, late high school and college.
I grew up in the 70s.
and we'll leave it there. I just never had any interest because I had friends that did it all the time. They always tried it. I was like, no, I'm good. And they finally got used to quit asking him. He's not going to do it. And I just
got upset because I was promised all these free drugs as a kid that I never got as an adult.
Well,
I was told that there was going to be somebody standing on every street corner trying to shove
that was
drugs.
the guys offering you candy, Tom. Completely different. You see, that was the problem. You were
But they'd always
confused.
drop me off down the block. I don't understand.
Yeah. Oh, no, not him. We don't want the fat kid.
Shove me right out the door.
Yeah.
Like, yeah, no, get rid of him. But how you doing, Ron? It's been a tick.
All right, thank you. Good to see you again. Yes, Tom.
Interesting news going on with Miss
Yes, indeed.
Gina Carano and stuff. Yeah.
Let's actually dive right into this. So just as a precursor to what we're about to discuss, these are some of the articles that have been out there today. Ron was here in the last week or two where we had the discussion about the motion to dismiss that was denied by the judge. The motion was filed by the Walt Disney Company. They want the case to go away. Judge says, nah, I want to hear more. I don't want to just dismiss it, so it's going to proceed. According to the document that we're about to show you, that Ron is going to kind of cover some of the ins and outs of, so we know what's real and what isn't. It looks like we have a court date, or at least an initial trial date, set for sometime in September, I think it was, as mentioned in the document. I think maybe around mid to late September, 15th to 25th. I don't remember. It's in there. I know I saw it somewhere, maybe in the article. But there was something else filed in the last couple of days on July 26th. And this is what we've been seeing. Gina Carano calls on Pedro Pascal, Bear Grylls, and others to testify in her Mandalorian lawsuit. And what this is from the Independent, UK Independent. Gina Carano has called on Mandalorian co-star Pedro Pascal to testify on her behalf in her discrimination and wrongful termination lawsuit against Disney and Lucasfilm. Pascal was listed as a key witness in court document filed by Gina Carano on July 26th. Jon Favreau, British adventurer Bear Grylls, ex-Disney CEO Bob Chapek, Lucasfilm president Kathleen Kennedy, and Lynn Hale, the creator of the publicity campaign behind the Star Wars saga's return, were also named as potential witnesses. So this is what has set off a storm out there today of videos, people discussing, could we see this? Could we see that? We've got Ron here to tell us what all of the actual possibilities are, but let's pull up the actual legal document here that I have queued up. 1 second. Let me flip this over. And like we were saying a moment ago, isn't it something now that, when it comes to modern journalism, all of these legal filings are so readily available almost immediately that we can have a public discussion on these things, especially cases of great public interest, at least in this community. So, Ron, walk us through here. What have we got?
Well, what we've got is a header. Okay.
Yeah.
This is called the joint report of the parties' Rule 26F conference. Rule 26 governs pretrial discovery in the federal courts. This conference, which is required under Rule 26F of the Federal Rules of Civil Procedure, is an informal discussion that takes place between or among the parties, depending on how many there are, where they fill out a form that's provided by the court. Each court has somewhat different requirements as to what they want to know about. And you can think of it really as a way to get across to the judge how busy this case is going to keep him or her. It is not, by the way, folks, you don't have to pay Scribd for this. This is all available for much less money directly from the federal government. You do have to get an account on Pacer. But once you get an account, you do have public access to all unsealed documents. And instead of paying somebody, some delta of profit on this, which is fine. It made it easier to find. But you can get stuff like this for a couple of bucks at the most.
And just for the record, I didn't pay for this. I think I clicked on a hyperlink from an article that took me here. So
well, that was a good move and good for Scribd, which is, by the way, a fine service that I have an account on and like very much. What I'm trying to say is that it gives the judge a case of a sense of how big the case is. Is there going to be how many documents are going to be involved? How many witnesses are going to be involved? Keep in mind, this is what I thought. See that proposed trial date? You didn't mention the year.
Oh, I'm sorry. I didn't even notice that. Thank you for pointing that out.
I was going to bring that up, how far in the future this is.
This is going to trial in September.
I wondered, I saw September. That's all I think what happened was when I glanced at this while I was running to lunch, I probably saw the original complaint year, 2024, and then I looked down and saw September, and I just erroneously put the two together. So apologies, audience. Yeah.
That's what we basically call a control date. In other words, it is very likely to move. There's going to be a motion for summary judgment in all probability, if there's not a settlement, of course, before that date. But this gives you a sense that the judge has, this is actually the party's submission. This has not been passed on by the judge. This is these are proposed dates. So let's now go through it, and I'll explain more.
All right, I'll just scroll until you tell me to stop, or you have a section you want.
Maybe you can shrink it a little bit.
Okay.
Because I think we're not getting the grand perspective.
Okay. Okay.
Okay. So I don't want to get too much into into the procedural details, but on this page, each party has a chance to tell the judge in a thumbnail what their story is. Plaintiff goes first. Obviously, makes sense. You can scroll down. We all know the story. We don't have to read her story. This part is not the kind of thing, in other words, this is a rather casual filing. Of course, everyone's super careful about how they put this stuff, but this is meant to familiarize the court. It's not like a response to interrogatories. It's not verified. It's not under oath. It's not a pleading. Disney's statement. Disney now tells its side of the story. What is expected of the parties at this juncture is that counsel for both sides be as bloodless and uncontroversial as possible. These are the facts, and here's why we believe it's not like a brief where you're arguing your point. It's super important at this stage of the submissions to establish to the judge that you know your job and that you're not going to take every opportunity to bang on the table. So, okay, let's scroll down.
Okay.
So this is, again, the story 1 and story 2. Boom, boom, boom. Scroll. Okay. The subject matter jurisdiction, the court needs to satisfy itself. Well, you went a little too fast.
Oops, sorry.
Number 2, paragraph 2. Okay, subject matter jurisdiction. This establishes that the court can hear this case. Why? Because each party is on the either side of the V is in a different state. So although this action arises under California law, we've discussed that in previous installments, even though each party, although it arises under California law, Carano could have sued in California court, or she could sue in federal court. If she had sued in California, Disney would have been free to move this into federal court based on what's called diversity jurisdiction. I've got a video on the topic of diversity jurisdiction on my main channel. If anyone wants to see that, let me know in the comments and I'll drop you a link. So let's scroll down.
Okay.
Legal issues, procedural issues. Okay, they're not aware of any, so I'm not going to go into what procedural issues there might have been. To some extent, certain legal issues will have been determined by virtue of the judge's, I think it was an 8-page opinion on the motion to dismiss. So the court will have made some legal rulings, but they will not be rulings on the claims themselves, but rather they do begin to form the direction in which the litigation will go. Substantive issues, this part is drafted by both parties together, and you can read it for yourself. But the main idea here, you see the last sentence, this is not an exhaustive list. Again, this is just meant to give the judge a sense of what's the case about. Mm-hmm. Evidentiary issues, parties not currently aware of any evidentiary issues. There will be evidentiary issues. There's going to be a lot of stuff that's going to come up, I think, in the nature of hearsay, chain of custody. I don't know exactly. I mean, I'm not intimately familiar. I'm not involved in the case, but there's no case that doesn't have evidentiary issues. Okay, number 4.
Let me ask you one thing on the substantive issues, because when I was reading this earlier, something jumped out at me, and I don't know if I really considered this before. The whole issue of, obviously, Gina Carano wasn't a W-2 employee of Lucasfilm. She was contracted labor to work on a show. So I'm going to play devil's advocate for a second. In this case, it looks like Disney is making an argument as to we couldn't have even terminated her because she wasn't even working for us at the time we made the statement. And Carano was saying that she still was. So I guess we have to wonder, was there a contract in place at the time of this occurrence, or if something had been promised or proposed to her, or like a rider in the previous contract with options to...
Well, and I think that's where Favreau comes in. And I mean, also, like, even if she wasn't still under contract at that point, the fact that they publicly went out, Lucasfilm and people at Disney owned that, that's what's going to hurt them, right, Ron? I mean, I would see at the end of the day, regardless. I mean, because, there's a lot of states that have a no-fault state where they can just fire anybody for whatever reason they want, and there's nothing you can do about it.
That's why I wanted to ask the question. If I'm Disney, I'm going to sit here and go, well, she had fulfilled her contract. Season 1 and Season 2 of The Mandalorian were both completed filming, post-production, and they had been released and completed on Disney+. We had not optioned, or we had not written a contract with Gina for Season 3 or for anything else yet. So playing the devil's advocate here, I'm assuming, Ron, if my analysis is correct, that's what Disney's trying to argue, is that we can't even be found at fault even if we did something wrong because she wasn't working for us at the time anyway. We didn't have a contract.
So there are a couple of levels to that. One of them is that, if you recall, the allegations in the complaint, which the court is obligated to accept as true, were that there were ongoing discussions about a much more substantial opportunity for her. And let's not even get into the question of W-2 versus 1099 employee. That isn't going to cut any ice at all.
Okay.
It's entirely reasonable to ask the question.
I didn't know if it would make a difference. Again, playing devil's advocate.
No, it's completely makes sense. But if you could get around employment legislation by hiring people as contractors, everyone would be a contractor.
True.
This has been litigated many times, but that's not exactly what Disney's arguing here. I think what they're saying is, as you put it, she had a gig. The gig was over. The allegations, however, are that she had been, as much as promised, I'm not suggesting that it's promissory estoppel, which is a form of contractual claim you make when you don't really have a contract, but everyone acted like you had a contract, and you lose out that way.
And there's actually another case involving Disney that had a similar situation with one of the original producers on The Acolyte. And that's how that thing went down. So that's why I'm thinking.
They just paid her off, right? Yeah.
They tried to give Karen McCarthy, I think her name was, the $5,000, which was like the minimum. Oh, this is what the PGA or the Writers Guild says we have to pay as a minimum for one day's work. She had all these emails saying, move to London, get ready to go, blah, blah, blah.
Yes.
And she did all this stuff. And then 2 weeks later, she had turned down jobs at Apple for a television show. And then they were like, we don't need you anymore, bro. And she was like, excuse me? She didn't have a contract signed, or so Disney said, but she had all these emails, like you said, that clearly conveyed that she was on board. This was go time. So
that's a classic example. That's a great example. And yes, it came up very recently, and it came up with Disney, of promissory estoppel.
Mm-hmm.
I don't think Gina's really making that kind of claim here, but to say that you were going to hire me and then you were going to engage me. It's not, again, we're not getting into the employee versus contractor. Mm-hmm. You were going to engage me and then decided not to engage me based on criteria that are prohibited to be used under California law. That's good enough.
Right.
It's sort of like saying I didn't discriminate you against you in employment. I just only let black people. I don't let black people into the post office to send an application in or whatever. I mean, it's a stupid analogy. The point is, if there
they
is
don't know how to use computers anyway, according to Bryden. So yeah,
that's right.
If there's discrimination and the discrimination is illegal, not hiring someone that you were going to hire, but for the prohibited criterion, is at least gets you to trial.
But Disney's going to give it a shot. And I think that's what, look, to Tom's point, that's why I was saying that I think that's one of the reasons, and we agree, because we've talked about this for years. We knew when this happened back in 2021, we had all been following what was going on with Disney and Lucasfilm, obviously. Jon Favreau, I think one of the reasons he's definitely on this list is because I'm sure, I go out on a limb and say I'm pretty damn sure that Gina and he had a number of conversations about her future at
even
Lucasfilm.
Emails and stuff, probably. Too,
probably lots of communication, text messages about. And one of the specific shows was Rangers of the New Republic, which had been touted by Kennedy herself and then summarily disappeared after Gina did. And by all accounts, Gina was supposed to be not just a lead, but pretty much the lead of that show.
There was two rumors around that. Either she was going to be a part of that, and that was going to set her up for her own show, or that was her own show. That was what we kept hearing. So it was one of the two.
One of the two. Yeah. So, all right, let's keep it going here. So
those are good questions.
Yep.
Parties evidence. Okay, that's pretty straightforward. Now let's get to the key witnesses and parties. So this is not a binding list.
This is not a subpoena.
This certainly is not a subpoena, because a subpoena has to be served on the person in order to be enforced, and that person has to be within the jurisdiction of the court.
Mm-hmm.
But these are the people that Gina's lawyers feel comfortable at this stage of the litigation saying, we're pretty certain we're going to want to talk to these people. I will tell you that the general tendency is to overstate this list.
Mm-hmm.
For two reasons. One is, if you don't even, you want to give the other side notice of your intention to use someone as a witness as early as possible so that they can't claim surprise.
Mm-hmm.
Number two is to put the fear of God into them. There might be 3 or 4 people on here that they realistically can't get to testify, or who they really don't want to testify because those people might not be friendly to Gina at all.
Mm-hmm.
But Disney doesn't necessarily know that.
Right. Gotcha.
So you want the other side to at least ask the question, would they really call Valliant Renegade? I thought Valliant Renegade was on our side on this.
I'll be there.
You'll be there as an expert, of course. So as long as you have a good faith basis for naming someone, you err on the side of naming them. On the other hand, certain names that are omitted, that especially like Bob Iger, that is obviously a policy choice that was made by counsel.
But it's okay. You brought up a name that I was going to throw as a what if kind of situation, Bob Iger. Again, in my opinion, Bob Iger would have had as much to do with this as Bob Chapek, which is probably to say at the time it might have been a lot or it might have been nothing. Because Bob Iger was still there. He's still the chairman of the board. He was the one that was reported widely, including by Alex Sherman at CNBC, all during that period of 21. He was really kind of running a lot of the studio system still from the board position. Chapek and the studio guys didn't get along very well. So that would be interesting. But again, it's like, what would Iger really say? And if by not having him on this list for the audience sake, if you don't list somebody on here, this doesn't prevent you or preclude you from adding them or subpoenaing them anytime in the future, right?
Correct.
Okay.
In fact, and what by omitting Iger so judges are correctly skeptical of people who say, I'm suing Apple because they didn't honor my warranty and I want to depose who's the head of Apple now? Come on, guys.
Oh, Tim Cook.
I want to depose Tim Cook.
Yeah.
You know, you don't get that. You don't get that. If, however, in the course of discovery, Iger's name comes up on emails, on texts or in Slack chats or whatever, or someone testifies that, well, we ran this by Bob, and he was very clear what he wanted us to do, something that gives you a real reason to go in and add him to this list. Now you have established your credibility by not asking for the big shot out of the box, but now you say, hey, look, we didn't think it was going to be necessary, but what do you know? This is someone who can testify.
Gotcha.
Well, and that was going to kind of go towards my question here is like, basically what this is, like you already kind of answered part of it, is this is more or less calling up that they probably have some sort of email and or text trail between the two of them. And if this doesn't necessarily mean Kathleen Kennedy is going to show up in court, right? It'll most likely, if anything, be a video deposition, I'm imagining, right, Ron? Or
no, there's no reason for. Okay, these are people who are witnesses, meaning that they are likely to be required to produce documents.
Okay.
And remember, if they work for Disney, they don't need to be subpoenaed. Disney is a party. It has to produce any employee on notice. Doesn't require a subpoena. She may be remotely deposed or deposed in person. That's a developing kind of situation. I prefer to do depositions in person because it enables me to make use of my commanding physical presence. But it's getting harder and harder to get away with the much more expensive and clunky process of doing in-person depositions.
We saw a lot of
remains to be
those.
seen.
I was going to say we saw a lot of those during like the Johnny Depp trial. You know, where
I was going to say that's what made me think of it was
in,
the videos. Yeah,
right. People were remoting in live into a courtroom, like it wasn't a pre-recorded deposition in a lawyer's office.
That's different.
Yeah.
Right. Okay. So
see, and that's what I was thinking. I'm sorry, Ron. Yeah, I should have.
Yeah.
Oh, you're talking about
specific.
Yeah. Let's I guess segregate the difference between a deposition in Ron Coleman's office versus somebody sitting in a courtroom or WebExing in or zooming in or something.
Right. My point was, let's not get too excited thinking Kathleen Kennedy herself is going to show up in court.
But it's a distinct possibility.
That's kind of what I was getting at. Yeah.
Tom,
okay.
it's a distinct possibility that she would. Of all the people on this list, yes, knee pain, I agree with you 100%. Of all the people on this list, she is one of the most likely to have to testify in person. Usually remote witnesses are people who are going to fill in a little piece of the chain, maybe a chain of custody issue, just connecting between D and F, but we're really going all the way to M. a main witness, someone who's a critical witness, you can, as a party, usually insist that that person, as long as they're not in another country or something.
Right.
And this isn't California, so that's not going to be the case. And California is a different country, but not from California. So
Yeah.
It is a whole other country over there.
yes,
Not a good one like
think,
Texas. So yeah.
I do think that if this case gets past summary judgment and there's a trial, some of these famous names will. I mean, this now there will not be cameras in the courtroom, ladies and gentlemen. Let's get that clear. This is a federal court. The federal judges don't go for this. You can watch appellate arguments, which is a very different thing. You can see 2 Ron Coleman Ninth Circuit arguments if you want, if you like California. Not every appellate court has video, but no trials are televised. That's the federal court's policy, and probably will be, I think, for a very long time, if not forever.
Let me ask you, if you don't mind, a couple of questions on 2
That's what I'm
things you
here
just
for.
brought up. Okay, so number one, I think I heard you mention, and good to see you, Jay, out there. Just in case you didn't see it, I sent you the link in your DMs. If you can join us, buddy. If not, no big deal, but I just want to make sure you're welcome to hop in. So my first question is, I think you mentioned something about that, if I heard you right, they wouldn't necessarily need to subpoena a bunch of individual names at Lucasfilm. You just said they'd have to make their employees readily available.
No, so, you don't have to subpoena. So there are 2 things when you want to take a deposition, and the same thing goes for getting someone to testify at trial. Everyone knows what a deposition is, right? A deposition is an out-of-court interview taken in by an adversary, where they basically preview what your testimony would be, but it's not taken the same way. In other words, I might call Gina Carano. I'm not going to depose Gina Carano because she's my client, but I'm going to put her up as a witness at trial. What you do at a deposition is you find out as much as possible about what that witness would say at trial, so that they have to stick to their story, and you can plan appropriately, and you go through documents and you ask them, what did you mean here? What did you say? And that's what a deposition is. It's on the record. These days, in a case like this, certainly it's videotaped, as well as being transcribed by a court reporter. It's taken under oath, and it's admissible evidence in both the cases of a deposition and a trial. There are 2 ways to get a witness to testify. One is if it's a third party, you serve that party, again, if the party is within the jurisdiction of the court, with a subpoena that says, under the authority of the Federal Circuit, of the United States District Court for the Central District of California, you are hereby ordered to appear on such and such date, such and such time, to give testimony. That usually ends up being negotiated. In contrast, anyone who's an employee and who is a proper witness, and there will be disputes inevitably about who is and who is not a proper witness, all I have to do is give the lawyer for the other side what's called a notice of deposition, which looks a lot like a subpoena, but it doesn't have to be served by a process server or in person. On the contrary, I can't have any contact at all with the individual. I have to go through the lawyer for the company, but they have to produce everything, both documents and witnesses, that are under their custody or control.
Got it. And that's kind of mostly part of the discovery process, I guess, in that.
Yeah, that's what it is. Yeah.
Okay. Gotcha. Yeah. Cause there's one name on this list that's glaringly absent to me, and I'll let the audience take a guess at who that might be. And others out there that are part of that Lucasfilm.
Hidalgo.
And others in that inner circle that were there at the time and still there at Lucasfilm. I mean, guys like Dave Filoni aren't named either.
Wait, can I get a retake on that? I can do much better.
Well, I mean, we can all, hypothesize.
Pablo Hidalgo.
We'll find out.
There, I think it has the dramatic essence it needed.
Now, this next section here, Ron, this is where they start listing off. This is seemingly, hey, this is what we want, this is what we got, kind of thing, right?
Yeah. And this is stuff that probably anyone watching this could have come up with this list himself.
Right. And you're looking at Gina Carano's social media posts, communications between and or among employees of Disney and or their subsidiaries, contractors, other related entities related to Carano's social media posts. So basically, there we go. Anybody working at Lucasfilm, the whole Lucasfilm story group, people love to throw Pablo Hidalgo's name around, throw him in there, throw in anybody that would have been emailing back and forth or using Lucasfilm Slack chat or whatever, DM, stuff like that. Hey, this is what we want to have. We want to have access to all of this to see what happened here. And if anybody, chatted with Pedro or anybody else involved with the show related to Gina and all this going on, we want that. So they're asking for everything. They want copies that Disney has of Gina Carano's contracts with Disney, communications between Disney and Carano's former talent agency. And that's who you see on this list. For those of you that don't know who that is, the UTA, United Talent Agency. That was the talent agency that was representing Gina Carano. And they terminated their contract with her at the exact same moment that Disney terminated its relationship with Gina. So I'm sure they're going to have some questions there. Document showing plans here, and here it is, plans for Rangers of the New Republic series, as well as other series or movies in which Carano would have a role. So again, like we talked about before, and I didn't read all this earlier, so I'm reading this cold, and I'm saying, yep, these are the kind of things that I would suspect. This is what she's going after. To Ron's point earlier, is that if they had designs, and there's evidence that they had designs on bringing her in for another show, and then all of a sudden that's gonna go to help Gina's case as well, I would imagine. Document showing compensation Carano would have earned had Disney not unlawfully terminated her promised projects, including but not limited to future seasons of Mando, Rangers of the New Republic, Star Wars films that were to include the Cara Dune character, which, of course, now that is Mandalorian and Grogu for sure. She would have been in that movie, no question. Social media posts made by Pedro, Mark Hamill, and other similarly situated employees or actors, meaning that they were connected to Disney Star Wars, obviously. Documents related to Disney's treatment of similarly situated male employees or actors. Documents or communications related to Disney's public statements regarding plaintiff's termination. So whatever emails...
Remember, this document is educating the judge. Mm-hmm. Like, why does the judge need all this? Mm-hmm. We're telling the judge, this is the kind of evidence we're going to be relying on to make our case. Mm-hmm. You saw our summary, and you've already read our briefs on the initial motion to dismiss. Here's the kind of stuff we're going to be looking at. Mm-hmm. And which Disney's probably going to do its best to prevent us getting. I'm not talking about unethically, but they're going to some extent, argue on issues of, that also, but issues of probativeness. Relevance is not the standard, by the way. Mm-hmm. It's a much lower standard. We'll talk about that some other time. Also, though, in this case, where this is one of probably 50 videos or streams that are taking place looking at the same document today. Mm-hmm. This is also a document that is drafted with an eye to public consumption. So since this is a case that is being litigated in public, people need to get across their message, why they believe they've got a case, what evidence they're going to rely on, and what people should be thinking about when they choose sides, which, as we know, can be a very big deal.
Indeed. But I mean, any kind of email, DMs, anything related to public posts by Disney, Lucasfilm, for instance, the official Star Wars X page out there, formerly Twitter, right? So, I mean, the Star Wars Facebook page, Star Wars YouTube channel, anything, any communications with the people who run that would have posted something related to Gina's dismissal back in 2021. Documents or communications regarding or relating to Disney's diversity, equity, and inclusion programs and policies. Now, that's an interesting ask, but maybe unsurprising.
Unsurprising. It's probably going to be deemed too broad of a question, but you narrow it down. That's part of the fun of what we do.
Right. You always got to ask, right? Or you at least want to throw it out there at first. Let somebody tell you no. Documents or communications related to Disney's decision to terminate or dissociate from Carano and the reasons for that decision. And then we go here, and it seems like, we kind of discussed this earlier. Disney's position, right? So they're stating who, I guess, kind of walk us through what this is, if anything.
I don't understand why it's telling us all this about its corporate history in this spot. I don't think any of this is disputed, but they've got their reasons. Disney disagrees with Carano's list of witnesses, which is a strange thing to say. It's not the way I would put it. You don't disagree with someone else's list. You disagree with whether all the witnesses on that list are appropriate, but fine. That's they're putting down their stake on that. They name two other people, Carrie Beck and Paul. Is it Roeder, I think it's Roeder. And that's I was going to ask you this because I found that interesting. So they said, we don't like all the names on your list. We disagree with them as being germane to this case, I guess. But they added two others saying that these people would be. Am I reading that right? Like these people should be witnesses on your list, or Disney? Well, these are people on. We're saying we're not repeating. It's a little bit vague here. Without repeating those already enumerated, usually you say anyone you named, we name also. If you're interested in them, we're interested in them. What they're doing though is saying we're not necessarily agreeing to them. And yet they're saying, without repeating those already enumerated, well, you disagree with the list. So that doesn't strike me as the best. I'm sorry. Again, the lawyers who wrote this, the most junior one of them could buy and sell me several times over. But it's great. I don't think it's great draftsmanship. Disney says, but in addition to everyone on your list who we may or may not agree with, if I'm the judge, I would say, who do you agree with then? We identify these two, which they should have been. Now, this is an interesting point. Whenever you're exchanging drafts of this kind of document with the other side, you say, well, we add Carrie Beck and Paul Roeder, which the usual response is, oh, well, I'll put them on my list too. And this way you've got a joint list agreed on by everyone. Here, clearly, Gina's lawyers did not agree that those two belong on the list. And they didn't see any need, which there really isn't, to disagree with it. But they saw, now you guys tell me, who's Carrie Beck and who's Paul Roeder?
I was about to say, Carrie Beck is an interesting name. I would have thought that might have been on Gina's list, although Carrie Beck, I don't know how high up the ladder she was back in 2019, 20, and 21. Carrie Beck now, today, her name as an executive producer is on pretty much every Disney, Lucasfilm, Star Wars, everything. So Carrie Beck, she's been in the writer's room. She's responsible for a lot of the stuff that you see us rip on here on Valliant Renegade and other places like Geeks and Gamers and Midnight's Edge and Nerdrotic and everybody else. When we make jokes about The Acolyte, we make jokes about Mando Season 3, we make Carrie Beck is involved, Ahsoka, and involved in all these things. So that is a name in theory that, and I don't remember how far back her level of involvement. I mean, she's been there a number of years. She's part of the Kathleen Kennedy Star Wars Girls Club. I mean, she's up at the top, way up at the top. So that's an interesting name. Paul Roeder is somebody that, I believe it's been only less than a year. He was promoted to an executive vice president position at Disney for communications for Disney Studios. So his name may be on that list because, and I kind of wonder, was Paul the guy that helped craft the message that went out to all Variety and everything else? That's possible. He was in communications, I think, back in 21 when all this happened. He's at a higher position now, but I don't remember where he was at 21 when all this went down. So but like Carrie Beck's the one that jumped out at me. It's like people that know the business side and the writing side of Star Wars, like Tom knows who Carrie Beck is. We all know who Carrie Beck is. I saw that name. I'm like, yeah, sure. She's a real sweetheart.
She's actually one of the,
as my late father used to say, A beauty, a doll.
Yeah,
I
exactly.
was gonna say, yeah, she's one of the ones that we've been saying has been possibly being groomed to take over for KK one of these days.
Yeah, I would say if Kennedy were to step aside tomorrow, and I've been saying this for a couple of years, is that I kind of always saw Lucasfilm having a two-pronged studio head where you'd have a business manager and a creative head, and your creative head's going to wind up being Filoni. Your actual studio boss, business financial operations manager, somebody like Carrie Beck, or if she sticks around, Lynwyn Brennan, who is currently the general manager of Lucasfilm, has been for years under Kathleen. Lynwyn Brennan basically runs the day-to-day operations, but Carrie Beck might be a next closest thing. So, any case, there you have it. That explains those names. Going down, we come to the damages side, or is there anything else in that section I think you want to address?
Well, just that damages, sort of a little bit of an, I think, unintentional segue, that they say, in addition to what Gina listed, we're going to want to see documents that support her damages claim and her lost job opportunities. That's their way of hinting. We don't really think she lost any job opportunities. We made her, we can break her. I am surprised there's an emotional distress damages claim here. Usually in business law, we stay away from that because it puts your entire mental, emotional, and social landscape into issue. So let's see if they really keep that in. I think it's a big mistake, unless something, it's not like she has had any notorious, events happen. I don't see why you would keep that in there. All right, back to now to the damages section.
Yep.
Okay, so this is the first time where this is one of the trickiest parts of commercial litigation, and this is technically, it's civil litigation. I don't know. Yes, it is commercial litigation because it's a breach of contract, basically, except that it has the aspect of the discrimination. Compensatory damages for her loss of employment from the day of termination, loss of future, all the things you can read. Attorney's fees and costs, unless the Unruh Act provides for those, which perhaps it does, those would not normally be included in damages. This is really a placeholder. No one ever puts anything meaningful here, and there's nothing meaningful in this document either.
There's no ask for an amount. It's just we're seeking damages based on this, and they'll probably come to something later.
Oh, yeah. Well, ultimately, the amount is going to be contained in one or more expert reports.
Gotcha. If we get that far.
Right.
Okay. Talking about insurance, I guess for liability insurance or something along those lines, just stating that she doesn't have any applicable liability insurance. She does have a policy named Elon. So we'll go with that. Beyond this, motions, procedural, dispositive motions, want to explain any of this here or anything of value here?
Procedural motions, she may seek to amend her complaint based on evidence obtained through discovery. That's meaningless. If you have a right to amend, you do, and if you don't have a right to amend, you don't. But what is meaningful is that the parties have agreed to a December 20th deadline for amending the complaint. That means that no motion would be required to amend the complaint, but rather she would presumably be allowed to amend as of right. Dispositive motions, and what that might include, by the way, if she has a claim against the talent agency, she may amendment of the complaint may include bringing in additional parties. Gotcha. It also could include dismissing her emotional damages claim. Damages claim. Dispositive motions. So dispositive motions means motions that would get rid of the case one way or the other. We already had the big dispositive motion, the daddy of them all, the 12b6 motion to dismiss for failure to state a claim upon which relief may be granted. And it was denied. The parties may move for summary judgment. Of course they may. That's Rule 56 of the Federal Rules of Civil Procedure. And it is certain that they will move for summary judgment. Summary judgment is a step beyond the motion to dismiss, which was ruled on a couple weeks ago. Summary judgment says, Judge, both sides have had a chance to take depositions, to exchange documents. And at this point, we can tell you there's no reason to have a trial. Mm-hmm. They got nothing. And we don't have to take 12 or 14 people and ruin 2 weeks of their lives and take up time in the court, blah, blah, blah. No reasonable person could agree that there's a bona fide dispute of fact about issue A, B, C, D. You can ask for summary judgment or partial summary judgment. Let's leave it at that. They proposed June 11, 2025 as the last day for hearing dispositive motions, meaning that submissions would have to begin a couple of months beforehand. The fun thing for us listening to this about summary judgments is that that's when we really get to find out what's in the case. Because all the stuff that we're talking about, and everyone is so eager to hear about discovery, that stuff doesn't come in front of the court. It doesn't become public unless one of two things happen. There's a discovery dispute, in which case someone makes a motion and says they refuse to answer this interrogatory, or they refuse to answer this deposition question. Then that stuff goes on the record. Mm-hmm. But if in the routine exchange of documents, that stuff doesn't become public unless and until there's a summary judgment motion. And at that point, that's when both parties make their best paper case to either dismiss the claim, grant it in part, dismiss it in part. That's when it gets juicy. So it would be 9 months from now that we would start to see if everything were to continue and there were not to be a settlement, that the fruit of this discovery would begin to be officially public. That doesn't mean stuff might not leak. I don't know if there has been a confidentiality or protective order entered yet in this case, but summary judgment that's why that'll keep us busy even while the judge takes the usually considerable amount of time needed to decide the summary judgment motion.
Let me ask you something about, you just brought up, the length of time between where we are now in the legal process versus where we might actually see some of the, like you said, juicy stuff, right? If it goes to a summary judgment, obvious, if it goes to an entire trial and they're going to present evidence in it and that's going to be made public, is there, apart from what you said, unless there was something ordered by the judge, keep your mouth shut, is there something now to legally prevent either party from releasing some of this to the public, just saying, hey, look, here's the emails we had with Gina. We didn't do anything wrong. Or flip it around, Gina releasing emails saying this is what Disney did do was wrong. Just in the hypothetical world.
If there were not a protective order, it would still be unethical to use the discovery process as a way to generate publicity material. Mm-hmm. And if a judge perceives that one party is trying to gain an advantage in the litigation by litigating in public, or by litigating to the press, that judge will show her displeasure. And there could even be sanctions. So there's a difference between what's protected under a protective order and merely leaking like a sieve. Everything that comes out in discovery ends up public. In between, there's a certain amount of daylight. There may very well be things that will come out that may be appropriate to be released. They might end up being part of motions along the way. Judge, here's why we need this witness. Here's why we need this document. Here's why we want to add this party.
Gotcha. Okay. I was curious because I know a lot of people have questions about that. I've had people like make comments on YouTube videos, ask stuff in live chat. It's like, well, if I'll summarize them. If Gina has all this stuff, why not just do an interview and put it out there, right? That's the question I always hear. So, but if you're already engaged in litigation as they are now, it sounds like that might be a shoot yourself in the foot kind of thing.
Well, not only that, if she has all this stuff, she doesn't know what they have.
Right.
And even you'll hear me say this many times, and you already have, unless you have the full file, or using my old man references, unless you got the red weld, unless you really know what the case file contains, you really don't know the facts.
Mm-hmm.
You can drink your own Kool-Aid and believe, and after all, the lawyers only know what Gina tells them.
Mm-hmm.
They are obligated to do their due diligence that it adds up. But there could be a phenomenal amount of information from Disney that could change the case, could change the nature of her claims, could undermine her claims. So it would be a very, very foolish thing to go out with to go out with that stuff when you're missing so many pieces.
Gotcha. Makes total sense. And then they talk about the status of discovery plan. You kind of want to go through this briefly and tell us, what this means, if there's anything important here.
This is just to say that they had the conference that resulted in the production of this document on July 12th, even though it normally would take place at the very beginning of the case. But because there was a pending motion to dismiss, it was both sides agreed. We have no idea what we would be putting in here until the judge rules on the motion to dismiss.
Gotcha.
Discovery plan, nothing really interesting here. I think the Carano anticipates that the limit on the number of depositions may need to be modified. Modified never means reduced.
Right. We always want more. Why not get as much as you can?
The answer is, even if you're spending someone else's money, you don't want to waste your time.
Right.
And you don't need to talk to every single person in the mailroom and every single person at a meeting. If you've got 4 people who can testify what took place at a meeting that involves 7 people, unless you have reason to believe that one of those other people is going to contradict the testimony of the other 4, it's cumulative and it's a waste of everyone's time.
That makes sense. And they kind of say that here. If you look at depositions, Gina Carano intends to take at least 10 depositions, including Disney employees involved in the decision to terminate Carano. Disposition of each defendant, distinguished experts, third-party employees or entities for information relevant to damages, so on and so forth.
You'll see a reference here to a Rule 30b-6 deposition.
Yes.
A Rule 30b-6 provides that you can depose the company. In other words, someone can be designated to speak on behalf of the company with respect to one or more issues. In order to depose someone under Rule 30b-6, or rather to depose a corporate entity under Rule 30b-6, you have to specify the topics on which they will be deposed. Unlike in a Rule 30b-1 deposition, a normal witness deposition, where anything that could be probative or could lead to the discovery of relevant evidence is in play. Under the 30b-6 deposition, your notice gives topics, and they can then designate different people for different topics, but they speak for the corporation. Frequently, there's not a gigantic difference between, say, what Chapek would say, and on behalf in his role as a Disney executive,
mm-hmm.
and what would be construed as the testimony of the company itself. But you want to make sure there's no daylight at all, and you do, and it is always the case that 30b-6 depositions are taken.
Gotcha. Then they go into the Disney's position. I don't think there's anything groundbreaking there. protective order, and this is where they asked for what you were talking about before. The parties
Right.
agreed to enter into a suitable stipulated protective order for protection of documents or information containing confidential, proprietary, trade secret, or private personal information that may be subject to legal protections. So we'll share what you got, you share what we got, or whatever, and nobody's going to, we're not going to put it out.
Show you mine.
Yeah, nobody's going to put it out there for public consumption, of course, unless we reach one of those thresholds you mentioned before, summary judgment, or we go on to trial, right?
Well, keep in mind that's not actually quite what it says.
Mm-hmm.
What the first paragraph says, Valliant, is that this is meant to protect documents or information containing confidential, proprietary, trade secret, or private personal information. That excludes, theoretically, a large percentage of documents that do not fall under the protective order. Now, what inevitably takes place in discovery is that companies, so what usually there are at least two levels of confidentiality. I designate this document confidential, or I designate it attorney's eyes only.
Mm-hmm.
That's the simplest bifurcation. Confidential means it doesn't go outside of the litigation, at least until the time comes when it may have to. And even confidential documents, in theory, may be disclosed to, may be filed under seal. But the courts don't really love that. And in a high publicity case like this, it's unlikely that there's going to be much that stays under seal. Attorney's eyes only is not likely to be legitimately invoked in this case. It's usually useful when two competitors are suing each other.
Mm-hmm.
So, okay, we know you need to know who our customers are in order for you to defend against the case, but I'm not going to let your client, that bastard who's competing against me, know the name of all the customers. Again, that can't necessarily last forever, but the point is there's routine over designation.
Mm-hmm.
And a lot of judges put up with it, and some judges don't put up with it. I think in California, they're a lot less patient with it. So stuff could come out, but again, it is an ethical and a tactical mistake to just routinely smear your discovery in the public. It's not the way to roll. The judge is on the internet, or his or her clerks are, and it's going to come back to haunt you.
Makes perfect sense to me. I think the rest of this just seems more, here's some dates,
Schedules,
basic schedules, procedural stuff. And you see their key dates, initial expert witness disclosures would be due by April of 25. Expert discovery cutoff and close June 2nd. So, anybody they're going to bring in to pour over the contracts that they would have signed with Gina, or if they get them, I'm sure in Discovery they're going to want them, the contracts that Pedro would have signed for The Mandalorian, and maybe some other cast members to make comparisons to. Who knows? But all of that will wind up being in there. But again, we know how Disney doesn't tend to like to wind up going into a courtroom with a trial. They have a habit of either trying to basically terrorize the other side into submission to just go away, or they themselves will offer some type of settlement, or in combination of the two, to make the other side go away. Doesn't seem like Gina's, running anytime soon. So I don't know.
Well, she has the upper hand. Having gotten past the motion to dismiss stage,
yeah,
she is playing with house money, both literally and figuratively at this point.
Yeah, mouse money. I think is what we mean. Mouse money. Yeah, you see what I did there. So I tell we had this is the joke portion of the show. Let me grab a few of these super chats. We've had some people patiently waiting, and thank you all very much. And we'll talk a little bit more, I guess, on this one. We've got a few other stories here I wanted to get to today as well. But I want to thank everybody again. Thank you, Brandon, for the gifted membership. Thank you again,
Well, that's
Tender
too bad. I
Warrior.
didn't want to get in on this conversation at all.
Yeah, not really. Tender Warrior, who gifted 20 earlier. We're going to thank Tender Warrior once again for sending that in. Skycast, who gifted 5. And then I think we got this one down here from Infinite Warrior. And then we're Infinite Wanderer. Packing Protons for 5 says, had 2 supers. One involving Tom sent in before showtime. Okay, StreamYard missing again. Hang on. Thank you, Packing Protons. Let me check the studio here. Let's see.
Shame, StreamYard.
I know. StreamYard, no worky. Hang on.
Shame. We know your name.
Let me get in here to the... I thought I had the studio pulled up, but apparently I didn't. I think I closed it by accident.
I think you need some music.
Dun, 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 dun. All right, let's
Actually, I think
go.
I got some elevator music.
Here we go. Let me look and see. It should definitely be here. You're right. It is. And Araxis. How did I not? There's several of them that got missed. I'm sorry, guys. Let me back up. I can't pull them up in StreamYard because StreamYard apparently lost these. Packing Protons for 5 says, theory, no settlement offer from Disney to Gina because they see this as a Chapek problem. And any dirt or mudslinging on Chapek is good for the other Bob, IGER. Thank you, Packing Protons. The question becomes, and it's a very good question, the issue, I would think, is regardless of what Disney thinks right now, regardless if this is going to be something, certainly if it goes to this point in the press, they can sit there and try to, we'll throw Bob Chapek under the bus on this one. Which, let's be honest, YouTube would explode because everybody's going to know how absolutely ridiculous that would be. We all know who made this decision. This was done at Lucasfilm. This was done at the Kathleen Kennedy level. This was done at the story group level. We know the players who were involved because they kind of didn't make many bones about it in many cases. They were cheering it on Twitter at the time. A lot of these people in the story group. So I think they try to be silly, but the thing is, I don't know, Ron. I kind of think Disney would still love to settle this thing and not go to court and Discovery. What would you say? Or do you think Disney would rather
love
fight it
to settle it for some lowball figure, but not a figure she's going to take?
Right.
And they would want the value to them would include being able to publicize how little it was. And not only that, I mean, it's a problem for them to settle it because there are strategic issues here. It does encourage future litigants.
Mm-hmm.
Every man and every woman has his price. So I imagine if they could get a good enough deal, but because Elon Musk has removed the financial pressure on the plaintiff side, that's a huge game changer.
Yeah, I think it's going to be interesting to see how that pans out. But
I've maintained for a while that, as the Joker said, this is not about the money. This is about the message.
Yeah.
And I'm not comparing Gina to the Joker. I'm just saying that's the point, right?
Right.
The Johnny Depp trial is a good example of how basically going into that, I don't think Johnny even thought he could win necessarily, but he knew that wasn't the point. The point was getting his side of the story out there, getting the video out there, getting the evidence out there, getting the audio out there so that the public could see it. Right. And I think that's the main thing here is Disney's dealing with somebody who doesn't really necessarily at the end of the day care about the money that she feels that they may owe her. They stole her career, right? Like that's what this is really about. And they besmirched her name. They got her blacklisted, all this stuff, she was a rising star. Like that's the thing that I hope her, lawyers bring up, and I'm sure they will, that this woman had already been in a Fast and Furious movie, had already been in, Deadpool. So she was technically adjacent to the MCU already. Next step was a Star Wars show. Bada bing, bada boom. She's only what 2-3 steps away from being a B to A-list actress in most films.
Well, look at all the cameos they had this weekend in Deadpool and Wolverine.
Exactly. She should have been in it.
She would have been in it. She almost 95% plus chance.
Her character is one of the funniest bits.
Yeah,
in the first film,
in the first Deadpool movie. Yeah, and they
the
brought
booby
back,
bit and all that stuff.
Yeah. The whole thing with the boob stuff with Colossus and everything else. She should have been in this movie, by all accounts.
Just makes me laugh thinking about it. Right?
The number of cameos they pulled in for Deadpool and Wolverine, even if she had just been in. Not to spoil too much, but that last scene where you had all those older Marvel characters show back up and had the fight scene, like she'd have been perfect in there. That would have been so. Anyway, but it just goes to show you.
And by B level, I just mean the co-star. I see some people are like saying, well, she's been in a lot of B level movies. I'm not talking about the movies.
Yeah.
I'm talking about she could be starring alongside, insert your lead actor here, right? Yeah. By this point is my point.
Yeah.
And she would have a Star Wars movie coming up here soon too. That's the other thing.
Yeah, by all accounts, she had a lot of upward momentum going for her.
That's my point mainly, yeah.
A few of these other things that I cannot pull up in StreamYard, so I apologize. Araxis, of course, gifted 5 channel memberships as we started the show. I should have known something was wrong when I didn't see Araxis in there on my StreamYard side. Thank you, Araxis, for the $25 super chat so very much. Packing Proton's second super chat that he sent in that didn't make it. Did Andre and company kill the Apex bid for Paramount by pointing out the fishiness of it? Retraction timing happened as they talked about it.
We tore that thing apart worse than any of the everybody else did this morning. I guess somebody finally must have dug deeper and realized, I don't know if this is a real company or what this is all about. So yeah, you're going to lead into that. So yeah,
I had that article ready to go. In fact, I was queuing it up when I got home because I had it saved earlier. Matter of fact, let me flip it back. It's on my Apple News side. Was it this? No, it was the other one. I had it on Deadline. It was one of them. I got it queued up in the background. I'll find it in a second. But we're going to talk about that. Ruby Hoove also gifted a channel membership. Thank you, Ruby Hoove, for the Valliant Renegade channel membership gift. And FKHC 2005, keep up the good work, VR. Thank you very much. I appreciate you. And let's see. We got Brandon, we got Tender Warriors gift, we got Skycast. I think that gets us caught up to what we missed. So then we get down here to Liberty Hallscat gifted a channel membership. Thank you very much. And Weird for $2 says, "This is my blood. Jesus hands out molasses." Okay. I don't know if we had a reference to that earlier in the show. I must have missed something. WW Pro, what's up, buddy? Says, Ron, do we wait until 2025 to see Discovery docs, or do those hit public availability sooner? Well, I think we might have answered that since that question came in.
Yeah, it's unlikely that you'll see any substantial amount of it in the foreseeable future.
That's what it sounded like as we were going through it. Who also sends in a $10 super chat. Thank you, Pro. You didn't have to do that. Wednesdays never felt so good, Valiant. Welcome to dominating another time slot. Well-deserved, earned, and love watching my pal succeed. Well, thank you very much. Appreciate you. Yeah, Wednesdays, I never know. It's like a kind of a weird day. I know we never really get an audience like we do on the Sunday show, but Sunday has been established for like 3 years or so almost, or 2.5 years, I guess, at this point. So we didn't do live shows. I don't think I did a live show for about at least a year with my channel. But, yeah, getting there. Stitch says, there are only 3 lawyers that I like in this world, 2 old friends, and Ron Coleman. There you go. Oh, shucks.
Thanks again.
Thank you, good. So anyway, as far as that, with what we just kind of went through, we covered that story with Gina Carano with the lawsuit situation. I don't know if there's anything else that you wanted to add to this, anything else that you might expect, or kind of final thoughts before we.
Nope. I'm gonna pack out. I'm happy to be helpful here, and I'll be looking for the earnings call soon. Catch you guys later.
Next week. Take care. Hope
See
you
ya.
can make it.